5 seconds to go. Start. Explanation by the appellant, either by way of cross-examination of the witnesses or by way of his statement under section 313 CRPC as to where all these amounts had come from and why did he deposit huge amounts in the three accounts mentioned above. Rupees 29,50,000 is not an ordinary sum. Also, there is no evidence that in his account in HDFC Bank, the appellant has rupees 6 lakhs. Further, a very sizable amount is shown to have been paid to Rahmana Yusuf Faruqi in her account in State Bank of India. How did the appellant receive all these amounts and from where are questions that remain unanswered in the absence of any explanation and more particularly because the appellant had no ostensible means of livelihood. It would have to be held that the appellant was dealing with huge sums of money and he has no explanation therefore. This is certainly to be viewed as an incriminating circumstance against the appellant. The silence on this issue is only telling of his nefarious design. It is obvious that the appellant was a very important wheel in the whole machinery which was working against the sovereignty of this country. All this was supported by the fact that 9 deposit slips, the bank forms for opening the accounts, the slip through which the amount was deposited in the account of Rahmana Yusuf Faruqi were all proved to be in the handwriting of the appellant. We have absolutely no reason to reject the evidence of the handwriting expert. All this suggests that the appellant was weaving his web of terrorist activities by taking recourse to falsehood one after the other, including his residential address and also creating false documents. In these review petitions, the challenge is raised principally on 4 grounds. The concerned courts committed error in allowing call records to be admitted in evidence in the absence of an appropriate certificate under Section 65B of the Indian Evidence Act 1872. The disclosure statements of the review petitioner must be taken to be inadmissible on account of ill treatment meted out to him during the intervening night between his actual arrest and his formal arrest. The recovery of ammunition or the encounter of one Abu Shamal, who was stated to be the accomplice of the petitioner at Batla House, New Delhi, could not be associated with the disclosure statement of the review petitioner. Any possibility of retribution and rehabilitation of the review petitioner or that he would continue to be a threat to the society was not considered by the courts. On the other hand, it is submitted on behalf of the state that the scope of a review petition, even in matters arising out of award of death sentence, would be extremely limited. Reliance has been placed on the decisions of this court in Vikram Singh alias Vicky, Volia and another versus State of Punjab and another, and especially the following paragraph. In view of the above, it is clear that scope, ambit and parameters of review jurisdiction are well defined. Normally, in a criminal proceeding, review applications cannot be entertained except on the ground of error apparent on the face of the record. Further, the power given to this court under Article 137 is wider and in an appropriate case can be exercised to mitigate a manifest injustice. By review application, an applicant cannot be allowed to re-argue the appeal on the grounds which were asked at the time of the hearing of the criminal appeal. even if the applicant succeeds in establishing that there may be another view possible on the conviction or sentence of the accused, that is not a sufficient ground for review. This court shall exercise its jurisdiction to review only when a glaring omission or patent mistake has crept in the earlier decision due to judicial fallibility. There has to be an error apparent on the face of the record leading to miscarriage of justice to exercise the review jurisdiction under Article 137 read with Order 40 Rule 1. There has to be a material error manifest on the face of the record with results in the miscarriage of justice. Reliance has further been placed on the decision of this court in Akshay Kumar Singh versus State NCT of Delhi, where it was observed by this court as under. Stop.